Thank you. You can see I'm anxious to get going this morning. Good morning, everybody. My name is Vuono. I'm joined today by Justice Peter Rubin and Justice Mary Sullivan. We will be the panel hearing your cases today. Before we begin, I just have two brief reminders. The same rules that apply to oral argument in person apply to oral argument here on this remote platform. So you each have 15 minutes and there is no rebuttal. Second, upon occasion, we do have some technical difficulties, and if that happens today, we can assure you we will be patient with you, and we hope that you will be patient with us as well. And I guess I have a third reminder today, which is given the remote platform, sometimes it may appear as if the judges are looking someplace else, and we're only doing that so we can look at our iPads and our notes, etc., while we are also listening to your arguments, okay? So with that all said, I'm going to call the first case, which is Commonwealth versus Brian Smith, 2019-0101. Attorney Rotundo, the floor is yours.
Thank you, Your Honors. Attorney Rotundo for Mr. Brian Smith. This case rested on the credibility of the complainant. The two individuals involved in this case were in a prior dating relationship. They have a child together. There was testimony that from the complainant that their relationship was on again, off again. And further in the record, there's testimony that they maintain communications even before and after this incident. Now, the first issue in the case deals with the SANE nurse's testimony. Now, she testified that there were some abrasions on the right side of the right wall of the complainant's vagina. Now, that testimony went unchallenged, and the Commonwealth capitalized on that testimony in their closing argument. During its closing argument, they emphasized these abrasions. And just to quickly summarize, it's there that, summarizing their argument, it's there that this nurse sees the abrasions inside of her vagina, a depiction of what you'll have an opportunity to view in evidence. It was characterized and put down by this nurse. These abrasions inside this woman's vagina, there was a hospital record entered into evidence that further exemplified these quote unquote abrasions. Now,
well, let me just ask you this. There is no problem with the introduction of the medical records, right?
No.
Okay.
I have no objection to that. What it's essentially, the objection is that the testimony went unchallenged.
But it would have come in via the report in any event, correct?
It would have come in via the medical report.
Correct.
But you know, I cite a couple of cases in my brief: Commonwealth versus Quincy and Federico, and you know, the case law is pretty clear that there was ample room for a cross-examination in this area. I mean, it's proper.
So, if I may, for a moment, we don't have a motion for new trial, so we're looking at the cold record, and we're assessing whether or not a manifestly unreasonable strategic decision was made. That's our standard under Kolanovic. Is it manifestly unreasonable when made? When the Commonwealth asked the SANE nurse whether or not the abrasion was consistent with sexual assault, the defendant objected, and his objection was sustained. So he made a strategic decision, it would appear, that he didn't want any discussion of this. Why is that ineffective?
Well, in that respect, because that would impede on an ultimate issue in the case. However, it is proper for cross-examination on the medical interpretation of specific findings. And it's proper for a medical expert to testify that the presence of physical injury does not necessarily indicate sexual abuse occurred. In the absence of physical injury does not necessarily indicate that sexual abuse did not occur. So our argument is that the jury had no benefit of that. So the jury is thinking, hey, we have abrasions, therefore we must have some type of sexual abuse. I mean,
I have to put in, excuse me, I think maybe I'm just saying the other side of what Justice Sullivan has said. you haven't put in any evidence before us, and you haven't filed a motion for a new trial to demonstrate that this particular type of injury is equally consistent with consensual and non-consensual sex. It's certainly true that there are these old cases that say, you know, evidence of sexual intercourse isn't evidence of non-consensual sexual intercourse. Your trial counsel, maybe wrongly, maybe ineffectively, seemed to be concerned that these abrasions were somehow more consistent with the description of the rape by the victim than with consensual sex, and didn't even allow inquiry in that direction by the Commonwealth. Now, if you had put before the trial court on a motion for a new trial evidence that this is, that you can't tell anything from this and that it shouldn't be relied on, then maybe you'd be beginning to get somewhere, although of course you'd also need to show prejudice. But how are we supposed to decide in this case that these injuries are equally consistent with consensual sex such that it was an error not to object?
Well, I base my argument on the two cases that I found and put in my brief. You know, I would argue that it should be common knowledge for the defense attorney who experienced in doing these type of cases. When you cross-examine a sane witness, a nurse, this is cross-examination 101. I mean, if this nurse testifies,
I don't understand how it's cross-examination 101. If you don't know the answer to a question, you don't ask it. Now, maybe the lawyer needs to know the answer to this question before going in. That might be ineffective if the answer is more consistent with or equally consistent with consensual sex. But we have a detailed description from the victim of her turning in certain ways, trying to resist what she alleges and the jury found was a rape. And it's possible that a sane nurse could say, I have no idea, right? This is not an area of my expertise, but it's fully possible a sane nurse could say, well, abrasions on this wall of the vagina indicate that they occurred while a person was in X position, and that is consistent with her story. And that might be damning. So you might not want that. I don't know what you want, of course, because as I say, you didn't bring in an expert to do this. You still can, I suppose, on a motion for a new trial. But how are we supposed to know that this is equally consistent with consensual sex so that anyone would have known, cross-exam 101 you called it, that this is what they should have done? I don't know the answer to that.
well, I appreciate your input, and I would at this point rest on my brief for that for that argument. And furthermore, with regards to arguments 2 and 3, I would like to rest on my brief as well.
Okay, well, let me just see if the panel has any further questions of you with respect to the remaining issues before we move on to the Commonwealth's argument. Any questions from the panel regarding the other remaining issues? I see none. Okay, thank you very much for your argument. We'll turn now to Attorney Kenny for the Commonwealth.
Sorry, I had muted myself. Apologize. Good morning. May it please the court. Jessica Kenny on behalf of the Commonwealth. I'll very briefly address what the court seemed to be asking with regard to issue number 1, and that is obviously the lack of a record with a motion for new trial. I would take this even perhaps one step further, and even if there was evidence that the sane nurse would have testified the way that counsel believes that she would have, namely that you can have abrasions from consensual sex as well, I suggest that she wouldn't be able to offer that opinion about this particular case. And the case law is very clear that while a nurse or a doctor can testify that an injury is consistent with penetration or lack of penetration, the ultimate issue of whether it was consensual or not is for the jury to decide. And I would suggest—
How can you have argued, I don't know if it was you or the prosecutor, it sounds like you're making your brother's case. You argued during closing that this indicated non-consensual sex. And you're certainly correct that there is case law saying abrasion, at least generically, or evidence of penetration, doesn't tell us anything about consensual or non-consensual nature of a sex act. So why shouldn't there have been objection to you drawing an inference that maybe isn't right at all? It's equally one way or the other.
Well, for two reasons. One, because this defendant denied any sex with this victim whatsoever. So the presence of that injury, the presence of evidence of penetration completely counters his 22 minutes of a 24-minute interview where he completely denied any sexual contact with her.
Isn't that first? Wait, that was at first, right? Wasn't there evidence, DNA evidence found? I don't remember. I know there was evidence of more than one man, but there was DNA evidence that he did have sex with her, right?
There was DNA evidence found on the inside of her pant crotch. And the testimony was that she was not wearing underwear. So she testified that he ejaculated. No sperm cells or DNA was found anywhere on the actual vaginal swabs of her body, but on the inside of her crotch, I believe it was 6 sperm cells were located. And then when that was,
one is probably enough.
well, what was analyzed was the non-sperm fraction of that. And again, that was a mixture of 3 individuals. We know that she has a couple sons that she lives with, and that the defendant's profile, however, was consistent with one of those contributors. So one, the fact that she referenced in her closing, the prosecutor, that there was these abrasions is very relevant to his denial of any sexual contact to begin with. But it's also consistent with the victim's disclosure of how this rape occurred. You remember she testified that she curled up into a ball, that she was forced into these positions. She testified that it was painful. I'm sorry?
I raised that with your brother. I raised that with your brother, but you've said correctly that there is case law indicating that evidence of penetration doesn't tell us whether it's consensual or not. And even a case, what is it, Gardner in 1971, which is quoted in Montairo, which is one of the cases your brother relies on, which says that abrasions don't tell us whether it was consensual or not consensual. Now, I have a hard time getting there as a matter of law, but you're saying it doesn't matter, right? Your position today seems to be it doesn't matter, even if it's equally consistent with consensual and non-consensual. And that I don't see.
Well, this is why we don't allow a doctor to testify that an abrasion equals non-consent, because theoretically, somebody could consent to violent, painful sex. Consent is in your mind. It has nothing to do with the physical action. So you could engage in consensual sexual activity and still have injuries from it theoretically. My point is that it was admissible and relevant in this case because it was consistent with what the victim had indicated about this particular rape. And this particular rape was that she was
that's not how it was argued. Your brother is saying that it was ineffective assistance not to bring out that it's equally consistent with consensual and non-consensual sex. And we have someone here who at least arguably had sex with someone in the immediately preceding time period, not necessarily the defendant. Why isn't it ineffective to not, right? He's left the impression with the jury, trial counsel has, that this is evidence of rape. And you've just told me it isn't.
It's evidence consistent with her version of the sex that they had, which she says is non-consensual. So I guess you can say arguably that she had sex with someone, right? I mean, I don't even know, but the reason it's relevant is because it's consistent with her version of events, which is that she was in pain when he was forced.
But why isn't it ineffective not to point out to the jury, and equally consistent with the consensual sex that she obviously had, as there's evidence of her having had sex with at least one other person in the immediate time period prior to the same interview.
I'm sorry, there's no evidence that she had sex with anybody
there were
else.
3 men's DNA found either on the vaginal swabs. Am I mistaken about that? There's
On
something
her clothing, there was a
on the
mixture
outside or on the inside crotch of her clothing.
in the crotch, but from the non-sperm fraction. And she lived with her 3 sons.
Okay, it's the inside crotch of her pants. Now, I don't know what you're saying. How would her son's DNA get there?
It's not from the sperm fraction of the DNA. So it's not like it's her son's sperm on the inside of her pants, but
It's
it could
like
be her
someone's
son's spit up. It could be her son's skin cells. It could be any other place that our DNA comes from.
Inside the crotch of an adult woman's pants.
When we launder our clothes, they all get mixed up together. I mean, we find DNA skin cells everywhere. I mean, her children were young was the testimony. Her child could have, gotten sick on her lap. I mean,
How old are the children?
There were, I believe,
There's
all
4
under
children.
the boys, I believe, were all under, if I remember correctly, under the age of 10 or 12. And the youngest one, the defendant's son, was only a toddler, I believe, or an infant.
And when you say, I had misunderstood this, I thought this was evidence of sexual contact. You're saying it's not? When you say the non-sperm, does that mean that doesn't mean semen?
Correct. It was not from the sperm fraction of the
Sperm
DNA.
and semen are not the same.
I'm sorry?
Sperm and semen are not seminal fluid is what I'm talking about.
Correct.
I understand it's not from the sperm, but is it? I thought it was seminal fluid from other men.
No, that's not my understanding. Where they located the 6 sperm cells, they conducted scrapings and cuttings of that area, and they were able to extract profiles from the non-sperm fraction of those scrapings and cuttings, which means it could be from anything. It could be from urine, it could be from skin cells, it could be from hair cells, anywhere that our DNA is derived from or could be left. There was absolutely no evidence whatsoever that she engaged in any sexual contact with anybody, not from any witness, not from any testimony. The only evidence that was
I may have understood that. I just saw that there was this data of male DNA in the inside crotch or vaginal area of her clothing. So okay, that's my mistake.
So again, it's the Commonwealth's position in this case that even if at best case scenario, we don't have a record, but even if the defendant have been able to establish this, it would not be admissible from the nurse to testify as to how this could have occurred. Consent, your ability to consent has nothing to do with an injury that may have existed. And so I suggest that there was no error, and specifically there was no error with the prosecutor's closing. In this portion of the closing that the defendant is objecting to, she's actually not even making an argument. She's literally just repeating the factual evidence that the jury heard, almost verbatim from the nurse, and then pointing the jurors to the exhibit where they can review that for themselves to determine its credibility and whether it's relevant to her testimony. I mean, it's literally the most appropriate way that she could have handled this argument. There was no argument made about what this meant or about whether this was consistent or not, other than to say that they had this evidence that was consistent with her verbal testimony that she was in pain when this was occurring.
Counsel, how would you characterize the defense in this case?
The defense in this case was that the victim should not be believed. The defense attorney spent a great deal of time in his closing argument talking about how claiming that the physical evidence didn't match her recitation of what occurred, indicating somehow that there should have been more injuries, that there was only this one injury on her face. He actually mischaracterized the evidence by saying that there were no other injuries other than the injury on her face. Again, I would suggest pointing to his strategic decision to draw attention away from those vaginal injuries that were observed and were present in the medical records.
But let me focus the question more precisely. I read the closing as you just did, but is the argument that nothing ever happened, or that the sex was consensual, or is that left open?
I think it's left open because there's a point in the closing where the defense attorney actually says something like the defendant was telling the truth when he said they had sex But even the physical evidence doesn't match that. So I think it was a little bit of one of those, like, you can't really believe anything in here. And then the burden obviously is always on the Commonwealth. So you have to find him not guilty. But there were very significant attacks on her credibility throughout the case and in the closing, again, pointing to the fact that even though she went to the hospital after this, that she didn't immediately call the police and report it, pointing to the delay in her going to the hospital.
Just going back to consent, he initially denied any sexual contact, but correct me if I'm wrong, he ultimately acknowledged that he had.
Yeah, so there was a 24-minute interview that was offered to the jurors.
Yeah.
It was redacted. For the first 22 minutes, he denied any sex. Our clothes never came off. We never had sex. And then at about 22 minutes, he asks the officers, hey, by any chance, did she get a rape kit done? And the officers say, yes, she went to the hospital, she got a rape kit done. And then, and only then, does he say, well, we did have sex then.
Yeah.
So I think that was very strong.
I just wanted to confirm it. It goes to the evidentiary argument that the defense is making. The fact that he ultimately admits it actually cuts both ways in the case. But thank you. I just wanted to make sure that we were all on the same page with respect to the record. Thank you.
Certainly. If the court has no other questions, I know my brother rested on the second issue on his brief. I'm happy to do the same unless there's a specific issue the court would like me to address.
I'll check with the panel. Just one moment, please. And I'm seeing that neither of my colleagues here have any further questions. I don't either. Thank you very much for your argument. All right, so that concludes our first case. Just before you both leave, on behalf of the panel, we wish you all a very safe and very healthy new year. Okay.
You as well. Thank you.
Just a moment until we get the high sign that we're actually live. Sometimes it takes a couple of 30 seconds or so.
We're live.
Great, thank you so much. All right, good morning and welcome to today's sitting of the Appeals Court remotely. My name is Ariane Vuono. I'm joined today by Justice Peter Rubin and Justice Mary Sullivan. We will be the panel hearing your case, which I'm now going to call officially for the record, which is Commonwealth versus JAMAIL HAIRSTON 2020-0512. And just two reminders before we begin your argument. The same rules that apply to oral argument as if we were in the courtroom in person apply here. You each have 15 minutes to present your issues, and you can be assured that we have read the briefs and we know the transcripts and we have reviewed everything that you have provided to us. There is no rebuttal in the appeals court. And second, upon occasion, we have some technical difficulties. If we do, let's hope we don't, we will be patient with you and we hope that you'll be patient with us. Okay, so with that, let's start with our first attorney, which would be you, Attorney Cox.
Good morning. Jennifer Cox appearing on behalf of JAMAIL HAIRSTON. Mr. HAIRSTON is appealing from a judgment of conviction of assault and battery after a bench trial in Plymouth Superior Court. This was count 2 of the indictments against him, and it was a lesser included offense of the charged offense. So at his trial, Officer Pagan, a corrections officer at the Massachusetts Treatment Center where these incidents took place, testified that Mr. HAIRSTON refused to answer any questions about the sexual assault allegations after he was informed of his Miranda rights. This testimony was an improper comment on the defendant's invocation of his constitutional right to remain silent. Where there was no objection at trial, we review for a substantial risk of miscarriage of justice, and the defendant would argue that that occurred here, where the testimony served to imply his consciousness of guilt by failing to either deny the allegations or explain them when presented an opportunity to do so, and because the Commonwealth's evidence concerning this count 2 was far from overwhelming. So the first part of the analysis is the analysis for whether it was error. So I think I can be
I think you can probably pass that one because the Commonwealth concedes that there was error, and I think you can assume that the panel understands that that wasn't improper.
It's pretty fundamental principle, so I don't have much to elaborate on.
Which leads me to my question to you, however, since it is so fundamental, can we not assume that a trial judge, even one that does not have the wealth of experience that this particular trial judge has, would have understood that to be an erroneous comment? It wasn't actually solicited from the Commonwealth. It was it was the response itself was not really an appropriate response, if I could characterize it that way. Can we be fairly confident that in a bench trial that this judge would have ignored that, understood the principles of law that apply?
So in response to that question, that sort of goes to the fifth Mahdi factor, which is the availability of a curative instruction. And so the cases indicate that here, where the defense attorney did not object, did not move to strike the evidence, as far as the court, the presumption that a judge correctly instructs him or herself on the law does not apply here, where he was not requested to do so. And so I would cite to the Isabel case that's cited in, I think, both of our briefs, that says that there's no requirement, which was not a bench trial, but says that there's no requirement that a judge give a curative instruction sua sponte. And that also had to do with the right to remain silent. So here, I guess I would say that those two factors go together, where even on this fundamental principle, Isabel says there's no requirement that a judge in a jury trial interject to give a sua sponte instruction where it's not requested. Here, the judge is similarly not required to instruct himself that. But so recognizing that this is, I'm assuming, going to be a critical question in the court's decision on this case, in preparation for today, I have two cases to talk about that were not cited in my brief. They're not on the right to silence particularly, but it's on a bench trial and the court's instruction and what we do with that on an appeal. So in our case, I would argue falls sort of in between these two. So the first case is Commonwealth versus Gales. It's a 2016 unpublished decision from this court. Since it's not cited in the brief, it's 89 Mass Appeals Court 1117. And there it was the judge in that court, in that case, repeatedly asked the clerk to see the police reports, and then eventually was given the police reports. So on appeal, it was argued that this, was evidence that the judge should not have considered. And a panel of this court found that the presumption that a judge acting as fact finder properly instruct himself concerning the admissibility of evidence cannot be employed here. And the court said where the judge specifically asks to see the inadmissible evidence, and this is the important part, the appeals court cannot determine from the record whether the judge relied on it in reaching his finding, that's under substantial risk of miscarriage of justice, the decision must be reversed. And the second case, sort of on the opposite end of the spectrum, is a case that I'm sure you're all familiar with, which is the Marungu case, which is in the first complaint, fresh complaint. It was one of the seminal cases as we switched over in that regard, and that's at 450 Mass 441. And there, the court, in discussing whether in a bench trial, the presumption that the judge properly instructs him or herself, said that it did apply here because on the record, elsewhere in the record, the parties discussed the King case, the first case on it, and the judge acknowledged familiarity with the change in the rule. So they said that because there was a specific discussion about it, we know the judge was aware and cognizant of it, so we assume he properly instructed himself. So I would argue that this case sort of falls in the middle here, where Isabel says there's no requirement to sua sponte instruct even on this fundamental issue. Where the defendant, that's the harm of the defense counsel failing to request an instruction, failing to move to strike it, is that we're left with this sort of conundrum of, do we assume that the court did that even though there's no indication on the record and no request for him to do so. So that is my response to that factor. I think moving on to another factor that I think is going to be important for this court's analysis of the 5 Mahdi factors is the weight of the evidence of his guilt. And so for that one, I would note at the outset that this is not a Lattimore analysis. This isn't, is the evidence sufficient to go to the fact finder? This is, the court once has asked in these cases, not even that the evidence against him be substantial, but that it be overwhelming. So here I would argue both that it's not overwhelming and even that it's not substantial.
Would you say strong or overwhelming? Does it have to be overwhelming, or do we just look
that's
at
what the court
strength?
say is overwhelming, is the word they use here, and especially here where, and I would note in the Commonwealth's brief that they rely on some of the evidence that does not go to count 2. It's the evidence, a lot of it had to do with count 4, for which the defendant was acquitted. There was a bench trial, there was a not guilty verdict, and so for example, in considering whether the evidence against the defendant was overwhelming, we can't consider the first complaint evidence because the first complaint was only about count 4. It was not about count 2. And Derek Gaughan, the witness who said he walked by during it, also only went to count 4. That does not substantiate count 2. They also rely on the bruise on his bicep that was introduced as a photograph in evidence. That also, the complainant said happened during count 4. So that, it does not do anything to substantiate count 2. And if I'm sure you recall, but count 2 process of elimination based on the indictments and the dates alleged seems to be the allegation that while standing in the doorway to his cell, that Hairston reached in and grabbed either his buttocks or his front privates. For
I thought that it might be the wrestling that was seen by the eyewitness, right?
The wrestling seems to is count 4, because if you look in the indictments, there are dates on those. And so, that's the wrong sheet. So count 4, which is another count of indecent assault and battery, alleges on June 18th, which is the last day. That's the day that everyone is consistent is the wrestling on the ground and trying to put his hand on under the shorts.
But he was found not guilty of the indecent part.
Yes, so count 2, correct. Yes.
So how do we know? I mean, I see you're saying the date.
Right.
The judge knocked down one of the counts and acquitted on the other count.
Yes, the other 2 counts.
You
and
think
one
we
was
can tell? Because to me, the fact that it wasn't indecent makes me question. You say, I mean, obviously, what are we doing? We're looking behind verdicts, and we're doing. I don't love any of this, but it's. We do this with substantial risk. So all day long, we're looking at these things that are imponderable. But
right.
But if the judge found him guilty of the grabbing of the buttocks, the reaching in, there is no way to render that a not indecent assault, right? But wrestling could be rendered a not indecent assault if we don't know what it was all about and there is an eyewitness.
I understand.
So I had thought that's what he was convicted of, but
I can tell you that similar to what you're saying, I have spent a lot of time parsing out. I was trying to figure out which one is which. And, I think because it's a bench trial, there's no motion for bill of particulars. It's not entirely clear, but I have spent a lot of time doing exactly
but there was obviously there's also no special verdict, right?
Right,
So,
exactly.
So,
so I think it's the dates is the critical, because so for the count that I'm talking about, count 2, the indictment says it's between June 11th and 18th. Which coincides with the complainant's testimony that, this was the sort of the first incident and then happened occasionally throughout. So that explains why it would be sort of a diverse date.
That covers the 16th.
Yeah.
Yes. But
right. So you can imagine a judge uncertain. I mean, I don't know if judges really look at the dates, since in many cases, not even part of the offense, blah, blah, blah. But one might choose that one just because I don't know what day this happened on, and this covers the whole period. So, you know what I mean? So I'm going to say sometime during these diverse dates, he committed this crime.
Well, I certainly understand. I'm sorry.
From your perspective, what is count 3 then?
Count 3 is the allegation that on the 14th, which again is in the indictments and coincides with his testimony, that Hairston allegedly lifted him up over his shoulder and bit him on the buttocks. And so everybody sort of agrees that that's on the 14th, including Officer Pagan, who, when testifying about the video, says that where Hairston is seen going into his cell during that time, that was the opportunity for that to have happened. So again, like I understand the point and I don't necessarily disagree with it, but whether or not the judge in a bench trial reads the indictments and is aware of the dates, that they are part of the offense, and they did.
I think we can
coincide
assume that the judge is aware of the indictment.
Right. Yeah, certainly. But they did. The dates do coincide with what the testimony is. And as far as why the judge knocked it down from indecent assault and battery to just assault and battery, like I'm just drawing an assumption, but I'm assuming he sort of didn't credit the sexualized component of it, and maybe that comports with his rejections of counts 3 and 4, the biting on the butt and the one trying to put his hand down his pants that are more sexual. Maybe in concluding those were not credible, or whatever his fault with those verdicts was, that's why he knocked down.
Let me ask you a bigger picture question, which is, do we have to parse the evidence like this? In other words, do we have to determine upon which a date and episode corresponds to the guilty verdict. That part makes sense. But after that, when we're looking at the evidence as a whole to determine whether it's strong or, as you say, overwhelming, why can't we also look at the entire series of events?
Well, I think the cases intimate, especially where there's the two cases, and I think one is Mahdi, or it's maybe DePace and Pixoto that talk about, and I'll find them in my notes here while I'm talking, that the court's analysis is whether the problem with the invocation of the right to silence goes specifically to the issue at trial. So for example, in one of the cases, I think it was Mahdi, that it was an insanity case. And so the comment was, well, we can infer he's not insane because he successfully invoked his right
Here it
to
only
silence.
goes to consciousness of guilt, which goes to all of the counts.
Right, which does go to all of them, yes. So as far as parsing them out, I do think this court needs to consider that, one count was a motion for required finding, that was the open and gross lewdness, and then at least two of the counts, were entirely not guilty, meaning the judge didn't, credit some part of the testimony. But they had a lot of conflicting things.
Seems to me the judge credited where there was independent evidence, like of the.
Yes. So, and I apologize that I intended to send the video to the court, and then in the ensuing pandemic, I forgot to send it, but I do have a copy of it that I will send out in the mail to you today, just in case that elucidates any of it for you. But as far as that and the connection to count two, the video does show him standing in the doorway to the cell, and you do see him reaching in. Obviously, you can't see any grabbing or anything but the video, to the extent that it substantiates anything, as you're saying, it does show reaching in.
But the incident. Go ahead.
Sorry.
Excuse me. Go ahead.
We can't find that the evidence was strong or overwhelming for things he was acquitted of, obviously, right?
Yes, that is my argument.
We have to, so the sexual piece of it, he was fully acquitted of.
Right.
So we can't find that any of the evidence of anything sexual was strong or overwhelming. Right.
Yeah, but I think you can, and I don't have case law research for that, but I can imagine an incident where someone touches someone else's butt, and it's, it's assault and battery, but perhaps not indecent assault and battery. So I think, I'm guessing again, but I think that's what the judge was doing, that, perhaps unconsensual touching occurred, but that it did not have that, offensive nature. I'm forgetting the exact words of what the instructions are. But so unless there are further questions, I would just ask the court to consider that the language that the cases that discuss this use, continues to be that this particular category of an admissible evidence is so egregious that reversal is the norm rather than the exception, and ask the court to look at it with that eye. So thank you very much for your time.
What is your best case for the proposition that on substantial risk analysis, the evidence must be overwhelming?
There are numerous cases that talk about the overwhelming thing, but a good case for.
Yeah, go ahead.
Sorry, I was just for the for under a substantial risk one, there's the Andujar case that is cited in the brief, and that was where the Commonwealth.
That's okay. Your time's up. Thank you.
Okay, thank you very much.
Your time is up, but before you leave, I just want to say one thing. You brought to our attention two cases that weren't in your brief. Bringing our attention to cases that are helpful is always a good thing, but it's better if we know in advance, so we would have read them. And of course, I hope that your it also puts the Commonwealth at a disadvantage if they haven't had a chance to take a look at the cases. So
I understand that is my late.
I'm sure you do. I won't have to say anything more about it.
Okay. Yes.
I'll turn to Attorney Riley now. Thank you.
Thank you.
Good morning. Thank you. Patricia Riley for the Commonwealth in this matter, if it pleases the court. Your Honors, we'd ask that you affirm the lower court decision in this case. There was, the court should look at it, of course, with whether there was a substantial risk of a miscarriage of justice, because there was no objection made. We conceded that when the defendant was Mirandized, after he was Mirandized, the officer on the stand, as Your Honor had noted, not in direct response to a question, but kind of as an afterthought, just threw out that the defendant was,
Refused to answer any
Revoked.
questions.
I beg your pardon?
He said that the defendant refused to answer any of his questions.
Exactly, which
Yeah.
was a post Miranda. And as a result, the judge who, as you noted, this is an experienced trial judge. Judge Moriarty is an extremely experienced trial judge. He's presumed to have instructed himself on to ignore that, to strike it and not consider it. And I know just because the defendant had thrown out a case that was a 2016 case that wasn't cited in a brief, I am going to make this offer to the court of the case that came the very next year, 2017, which was an unreported decision, COMMONWEALTH v. Watson, which is 91 Mass Appeals Court 1112, which said that the judge is presumed to have instructed himself on the law and not to have relied on it for an improper purpose. And that proposition will stand absent contrary indication. There's no contrary indication that he relied on it. And how do we know that? Well, look at the verdict. Here's the defendant is charged with 4 different things. And the indictment does read on or between June 11, 2018 and June 18, 2018. And as Your Honor did point out, I'm sorry, Justice Rubin, that the date is not an element of this offense. When one is and I would suggest to the court, when one is institutionalized, days kind of blend together. And I will concede that defense counsel, and it did say that, how the testimony was all over the place as to the dates.
So what is it that you think the defendant was convicted of?
I think the judge who had the opportunity to see the video, which, although on that particular date, I'm not familiar with that particular date, it does show the defendant multiple times entering the cell of the victim in this matter.
Which date are you speaking about? Are you speaking about the date that's set forth in count 2 of the indictment, which is a series of dates 11 to 18, or are you looking at the date that's specified in count 4 of the indictment, which is one date only, June 18th?
Your Honor, I have not had the benefit of seeing the video, but speaking to the trial attorney, that video, and the judge had this, as you saw, he had all, my understanding is he was given all the video, as well as 6 particular dates of video, or six instances.
He saw a compilation that lasted about
Exactly.
28 minutes, right? I think in the end that the other videos, I'm not sure was actually finally introduced or not, but certainly as an exhibit were the half hour or so of the compilation.
And in that compilation, it showed on multiple occasions, my understanding is that the defendant went into the cell. And you're right in that the one allegation, or the one charge that he was found guilty of, that could be the one where the judge saw the independent corroboration by the witness named Goggin.
But wait.
So which one was that? I'm sorry.
I would suggest that was the one that the judge found, count 2, where he was found guilty.
Count 2.
He
Okay.
was found guilty of the one where there was independent corroboration of the actual incident.
Well, but your sister says that count 2 was the count, the one he was convicted of, the lesser included offense on, was the reaching in and grabbing of the buttock. Is that right? Can we tell which indictment alleged which acts?
No, the indictments actually just read on or between June 11, 2018 and to June 18, 2018. It doesn't specify which one. It's just indecent
But during
assault.
the
No, that's count 2.
That
says
is count 2, but that's also the other counts.
Count 4,
No.
I thought said June 16th.
My understanding is that it was on or between June 11, 2018, or 2011 through the 18th for count 2.
That's correct for count 2, but the next count says on or about June 14th, and the 4th count says on or about June 18th.
And I guess what I'm suggesting to the court is on or about again, in an institutional setting, it doesn't have to be date specific. And that
Okay.
video is from that particular time frame.
But how can we determine whether the evidence of the offense was overwhelming if we don't even know what conduct the offense was? Don't we at least have to send this back? That is, if the judge found the grabbing of the buttock based on a video that shows the defendant reaching in a cell and you can't tell what happens, that's a much weaker case than if he found the guilt based on the wrestling, where a third-party eyewitness says he saw the defendant wrestling someone in the cell. So how can we figure out how strong the evidence is if we don't even know what it is he was convicted of?
Well, I think the question is actually very specific, as if you're asking how that would apply to whether there was a substantial risk as a miscarriage of justice, if that's what you're asking.
Yeah, of course.
I think you'd have to factor into everything that the judge had to consider at that time.
But he acquitted of several of the charges. So obviously we can't find that all of the evidence was overwhelming or strong. It wasn't even strong enough to get a conviction.
As far as the indecent, correct?
Yes.
But
And only one assault.
And first of all, I'm not sure if based on Mahdi, whether we actually do need overwhelming.
All right, let's say we need strong.
Then you'd have to really rely on the fact finder who was there, who saw it.
Okay, what event is there strong evidence of? Because he was acquitted of one of the assaults and convicted of the other. Obviously, we can't say there was strong evidence of the one he was acquitted of, because he was acquitted of it. Even though you or I might sit here like we always do and say, oh, it's strong, it's overwhelming, it's whatever. The judge did not convict this man of 2 non-indecent assaults, only 1. So he didn't even find beyond a reasonable doubt that there were 2 touchings. And we can't tell which touching he found. How are we supposed to know which one we're measuring the strength of the evidence of?
I think when a judge is sitting in, and I'm no judge,
No,
but
you're a lawyer.
He's going to be assessing everything that's in front of him for each element of each of the crimes. So I think he was in the best position to assess everything, all the credibility of all the witnesses, to try and find which specific or if there was a specific incident that was proven beyond a reasonable doubt.
I actually, sorry to interrupt you. I didn't realize this before, but the docket does give us some information on this. And the docket entry says that charge number 2, A and B, bench trial, guilty, finding lesser included. Charge number 3, indecent A and B in a person is not guilty, and charge 4, indecent A and B is not guilty. So that's the one indictment that does have the diverse dates on it.
That's correct, Your Honor. I'm sorry if I wasn't clear on that. But
okay.
The one he was found guilty of was the one that was diverse dates. So
okay, I'm sorry if I missed that in the conversation. So now, all right.
So the question is whether or not the judge could have found that the wrestling match formed the basis for the conviction, entered judgment on count 2 on that basis, and entered in a not guilty on count 4 because he thought it was duplicative. And whether or not we can engage in that kind of reconstruction, or whether under substantial risk analysis, since that's a relatively high bar for reversal, and I looked at Andujar and I think the facts and the law as discussed by Justice Grasso and that are quite different. Whether or not looking at it at the case holistically, we can arrive at a conclusion as to substantial risk, and that's what we're going to have to think about.
Even under, though, without going to overwhelming, it looks to me like We have this case, I think it's cited in the briefs, Commonwealth v. Connolly, which says introducing evidence of a suspect's invocation of his right to remain silent is a serious error that may result in reversal of a conviction. We inquire whether the evidence created a substantial risk of a miscarriage of justice by considering 5 factors: the relationship between the evidence and the premise of the defense, who introduced the issue at trial, the weight or quantum of evidence of guilt. So we have to look at the weight or quantum of evidence of guilt. And I'm still not sure how I do that without knowing what it was he is said to have been proven beyond a reasonable doubt to have done.
Unless you look at,
I mean, I could look at the
each
weakest
event.
one, right? I could say, of all these touchings that could be this one, which is the weakest? And is it still so strong? But if it's the weakest, it may not be that strong.
I think what I would suggest to the court, though, is that the whole the basis of a Doyle error is that the verdict would have been different, but for the Doyle error itself. Would the verdict have been different? And that's what I think the court has to focus on. Would the verdict have been different? This is a case where the judge clearly thought something happened. There was not evidence beyond a reasonable doubt that it was sexual in nature. He had the benefit of listening to all the witnesses, including the defendant who testified. So clearly he knew something happened. He had the benefit of a corroborating witness that there was a physical, that Mr. Hairston was in the victim's cell, and that he was being physical, which was in direct contradiction to what Mr. Hairston said. He never had engaged in horseplay. And there was a photo of a bruise. There was also, and I would suggest you can consider the first witness.
The judge did not find that 4 things happened, right? He could have knocked every single one of these counts down to simple assault and battery and said, this guy touched this guy 4 times. The time with the reaching, the time with the lifting, the time with the wrestling, and whatever the 4th time is. And he didn't. He only found that he touched him once.
I have a slightly different question in the limited time remaining. Let's assume this were a jury trial, and let's assume the same statement were made, and let's assume that the judge immediately sua sponte instructed the jury, you were to disregard that statement and it is stricken from the record. Because that's essentially what a judge is supposed to do in a bench trial with respect to him or herself. What would our analysis be in the hypothetical jury trial where the jury is given that instruction? Would we still be looking at substantial risk? And if so, what weight would the instruction play?
I think if there was an objection made, then you'd be looking.
No objection. The judge does it sua sponte.
Then in that case, it would, I'm sorry. I
ahead.
would still say it would be a substantial risk of miscarriage of justice. And would the verdict have been different? And then you'd be applying the Mahdi factors, which
even if there were a sua sponte instruction that you are to disregard that and it is stricken from the record?
If on appeal, yes, Your Honor, I would think that that would be the appropriate standard. And the reason is that if they were, you'd still have to look at the verdict and apply the Mahdi standards to that. If there was no objection made, as in our case here, there was no objection.
What role would the instruction play in that analysis? Would we presume that the jury obeyed the judge's instruction? Would we be asked to do that?
I think you would, Your Honor, yes. And you'd, in that case, again, would the verdict have been different, but for that Doyle error? And that's when you would be applying the factors, which I just to suggest the only thing that really the weakest part would be that the Commonwealth introduced this by accident.
Your time's up.
Thank you.
Thank you for answering the question. Let me just check with it. Although your time is up, let me check with the panel to be sure they have no follow-up questions. I see none. All right, I want to thank you both very much for your arguments. They were very helpful. That we will take the case under advisement. again, answer back to you as soon as possible. And on behalf of the panel, we want to wish you a very safe and a very healthy new year. This always takes a few seconds. Just hold on.
We're live.
Okay, thank you very much. Good morning and welcome to today's remote sitting of the Appeals Court. My name is Ariane Vuono and I'm joined today by Justice Peter Rubin and Justice Mary Sullivan. The name of this case is Commonwealth versus ADELSON FEDNA 2020-0191. Before we begin your argument, I have just two reminders. The same rules that apply to appellate argument as if we were in the court in person apply here and this remote platform as well. You each have 15 minutes to present your issues. We've read everything you've submitted to us, and so you can get right to your points as soon as you would like to, and there is no rebuttal in the appeals court. Second, upon occasion, we have some technical difficulties. So far, we've had none today, but if we do, we will be patient with you, and we hope you be patient with us. Okay. With that preamble finished, let me turn the floor over, so to speak, to you, Attorney Del Signore.
Good morning. May it please the court, Tony Del Signore for Mr. ADELSON FEDNA, who I believe is watching on the live stream. And I'd just like to begin by highlighting the thread really that runs through all of the significant issues at the trial. And that's that each of the issues relate directly to Mr. FEDNA's knowledge or his intent with respect to both of the convictions in this case. And it's crucial because his entire defense really focused on his knowledge and his intent. You know, he testified that he had no knowledge. He didn't know that the house had been broken into. He testified that he had no intent to commit any crime upon entry. And he testified that he had no intent to threaten the homeowner when he pulled the knife out of his pants. So any errors and issues that speak to his intent, I think it's very likely that it gives rise to a substantial risk of a miscarriage of justice or to prejudice, as the case may be. So with that, I'd just like to begin with the first issue of the court's instructions on misdemeanor with respect to the breaking and entering charge. So the court instructed that purchase or possession of marijuana is a misdemeanor. It is not a misdemeanor. It wasn't at the time of trial, and it wasn't at the time of these events. That is an error. The Commonwealth essentially conceded as much in their brief. But contrary to the Commonwealth's point, that's not a technical error. That's an error that speaks directly to an element of the offense, and specifically one of the most contested element of the offense, because the Commonwealth had to prove that he had the intent to commit a misdemeanor upon entry, and that instruction authorized the jury to find that he had the intent to commit a misdemeanor on the basis of conduct, which is not a misdemeanor. And I understand that trial counsel requested and advocated for the instruction, but if finding someone guilty of a crime based on conduct which is not criminal, I mean, that to me is core substantial risk of a miscarriage of justice. And in addition to that, I would just say it's especially an issue because there was no evidence at all that Mr. FEDNA intended an actual misdemeanor when he entered the house. There was no evidence produced that he intended any kind of misdemeanor at all. So on that basis, I would suggest that the charge of breaking and entering for a misdemeanor should be overturned, and the judgment should enter for Mr. FEDNA.
Why should a judgment enter?
Because there wasn't sufficient evidence that he intended a misdemeanor.
Fish oil from the fridge, maybe, right? That might have been larceny under 1200. They weren't instructed on it, but there's sufficient evidence to support finding the misdemeanor, right?
Well, if the court had, if the jury had followed the court's instructions, larceny in a building, in a building. I'm sorry, were you?
No, go ahead.
Okay, well, larceny in a building would constitute a felony, and larceny over would constitute a felony. So if the jury had followed the court's instructions, which they're presumed to do, they would have found that
yes,
he had
the question for a retrial. The question for a retrial, if a conviction is reversed, the question on whether you can be retried is whether there was sufficient evidence in the record to support a judgment of the crime of conviction. In this case, I understand that if they'd been internally consistent, since it was larceny inside a building, even if it was under $1,200, it would have been the felony of larceny inside a building. But I think the jury would have been free to say, well, we think that his intent was to commit a misdemeanor, stealing some fish oil. And I don't think they have to be internally consistent like that, right?
Sure, but I don't think the evidence produced at trial suggests in any way that he had the specific intent to steal $1,199 worth of goods.
Isn't the black letter law that the intent to steal may be inferred from the breaking, and then the only fight is over the amount? I mean, I think this is an uphill battle. Once there's evidence of a breaking, the intent to steal can be inferred.
And my argument is that it seems like a strange inference that someone would break into a house with the specific intent to steal less than $1,200.
What about criminal trespass? Couldn't he be convicted of criminal trespass?
So I think that the Scott case is really instructive on this. In that case, it was a B&E for a trespass, but there was clear evidence that the intended crime was trespass. The gentleman in that case broke into a vacant apartment where presumably the only crime he could have intended is trespass. The homeowner, the landlord in that case, had repeated issues with trespasses, and had specifically erected barriers that were, the defendant in that case broke through to gain entry to the apartment. And there really was no other crime conceivably that would have been committed. Not only that, that was the crime contemplated in the prosecution. He was ultimately charged with breaking and entering for a misdemeanor, to wit, trespass. In this case, there was, the trial counsel never suggested anything about trespass. The Commonwealth's theory of the prosecution had absolutely nothing to do with trespass. To say that he intended a trespass, I don't think there's any evidence there to suggest that he may have committed a trespass, but that doesn't indicate that he intended a trespass upon entry. I don't think there's any evidence that he did.
And it's your view that purchasing marijuana from an unlicensed marijuana dealer is neither a crime in itself, nor aiding and abetting the crime of the seller, anything like that?
I don't believe the purchase or possession of marijuana is a crime, and I don't believe that purchasing marijuana from an unlicensed seller, and I can't imagine that someone would be prosecuted for aiding and abetting the distribution of marijuana for purchasing. I certainly have not seen a case in which that had happened.
You
so I don't believe that.
You agree that selling it without a license is unlawful?
Certainly, selling marijuana is unlawful if you do not have a license. But Mr. FEDNA, there's no evidence at trial that Mr. FEDNA was.
No, I understand.
But had, for example, the judge specified that there was a 2-ounce limitation here, then your argument would be different. Is that right?
I apologize, Justice Vuono. I couldn't hear your question.
Okay, I was saying that had the judge specified that we're talking about possession or purchase of over 2 ounces of marijuana, then your argument would be different.
It would be different, except, so yes, it certainly would be different in that the instruction would have been accurate in that case. It would not, I don't think, change my argument with respect to whether or not Mr. FEDNA intended a misdemeanor, because there was no evidence that he intended to purchase or possess more than 2 ounces. So yes, it would change the argument with respect to whether there was error in the instruction, but it wouldn't change my argument with respect to the sufficiency of the evidence.
No evidence about weight at all?
No, Mr. FEDNA testified that he was going to buy 1/8, which is 1/8 of an ounce. So that was the only evidence about weight.
And the minor didn't testify, is that right?
That's correct. He did not testify. If the court were to find that there were sufficient evidence of Mr. FEDNA's intent, I would also point out that there was, I think, an important error with respect to the court's instructions on the B&E with respect to the trial judge clearly understood that Mr. FEDNA his defense was, I didn't know the house was broken into. The jury instructions on breaking and entering really don't make clear in any way what impact that testimony would have.
If we were to reverse the conviction based on the instruction, that the only misdemeanor mentioned in the instruction is not a misdemeanor. If we were to reverse the B&E conviction, would we have to reach the instruction question?
No.
Or if we found sufficiency so that there would have to be a retrial if the Commonwealth wants to retry him, and I know that whatever his sentence for this is 6 months and it's subsumed within the other sentence that's not the assault sentence. But if we reverse only this one and the Commonwealth decides to re-prosecute, you can ask for whatever instruction you like in a new trial, right?
Yes, I don't believe you would have to reach the jury instruction issue.
However, if it were possible to re-sentence on a lesser included offense, we would, right? That is, sometimes when there is, let's pretend there were a crime called just breaking and entering, which I guess there isn't, although I'll ask your sister.
Well, Vinnie Combe stands for the proposition that there is no such crime as breaking and entering without an intent to commit a crime.
So what is it? Surely I can't go up to someone's house, smash the window, and walk inside without committing a crime, right?
I suppose in that case, that if in your hypothetical, the crime, if it weren't breaking and entering with the intent to commit a crime, then it would be straight trespass.
And also maybe malicious destruction of property or something?
Conceivably.
Well, if you break someone's window,
But-
wrongfully go in there.
Correct, but in this case, I don't believe that there was, I don't think there was sufficient evidence to say that Mr. FEDNA maliciously destroyed property.
Well, it's a joint venture question, right? I mean, I don't know the answer to that.
I suppose, I don't know. I mean, joint venture seems a bit strange in the application of.
If I don't believe, if the finder of fact doesn't believe that the defendant was kneeling and tying his shoelace when it happened, right? We don't really know what happened, right? Except there was a glass was broken to get into the house, a window, I mean.
Correct. That's correct. So if there are no further questions on the B&E charge, I'd just like to spend my remaining time on the assault with a dangerous weapon charge. As I argue in the brief, there isn't sufficient evidence for a jury to find beyond a reasonable doubt that he intended to threaten Mr. Luongo. Sorry, Justice Rubin, I thought you had a question.
Doubtless I will, I'm sorry.
Okay. So the evidence at trial, even in the light most favorable to the Commonwealth, was the homeowner burst into the office. He sees Mr. FEDNA rummaging around in a closet. And at that point, Mr. FEDNA turns, pulls a knife out of his pants, holds it pointed up near with his right hand near his left shoulder. And then twice the homeowner testified he either pulled back or leaned back. And the homeowner testified as if he were going to attack. Now, I will concede.
As if he were going to attack.
Absolutely. And I will concede. Well, Justice Rubin, I would concede that that's sufficient to prove beyond a reasonable doubt that the homeowner perceived a threat, but I don't believe that that's sufficient in and of itself. I'm 2 feet away from someone, and he lifts a knife up near his head, pointed slightly upward, not straight at the ceiling as you demonstrated from what I read, slightly upward, in a way that the victim characterizes, alleged victim characterizes as if to attack me. It sounds a little sufficient. Again, I don't argue that it's sufficient that he perceived the threat, but when you look at it in the context of he's backing up, okay, and I'm ignoring Mr. FEDNA's testimony. If he's backing up, if he's pulling back, that suggests a defensive posture, someone who is scared, who's retreating, not someone who is intending to assault.
Isn't that a jury question?
Well, it would be a jury question, except I think, I'm not arguing, I don't know if this speaks to your point. I'm not arguing that it wouldn't be a reasonable inference that he intended to threaten. That's not my argument. My argument is it's equally reasonable to infer that he was either threatening or he was retreating. And those two things are mutually exclusive. And
Equally so, if you're looking at the evidence in light most favorable to the Commonwealth?
I believe so, because again, the homeowner, I'm ignoring any testimony by Mr. FEDNA. The homeowner has
But you must,
testified.
right? We look at the evidence at the close of the Commonwealth's case, right?
Absolutely. And so Mr. Luongo stated he took a knife up, held it near his own head.
No, I have read the testimony, yeah.
Okay, and then pulled back or backed up, and it's really the pulling back and the backing up in conjunction with the fact that there's no other testimony that he threatened. This isn't like, say, the Foley case where the person is verbally saying, "I'm going to stab you," or there's no advancing, there's no swiping, hitting. There's no additional indication of what Mr. FEDNA intends, and what he intends is crucial. And I think if we were to say, well, the homeowner testified that it looked like he was going to attack, if that's all that's necessary, then I feel like those two elements are simply merging, and whether or not there's sufficient evidence, that issue kind of goes away.
I mean, it seems like a permissible lay opinion in that it helps the jury figure out what the meaning is of these various acts of lifting up the knife, pointing it a certain way, and so on. It seems like we would let a lay witness say, not just he pointed the knife at a 45-degree angle, but as if to attack. I mean, I don't know. To me, that seems almost necessary, because otherwise the jury is left with a series of facts that are hard to understand what they mean unless they're put together somehow.
I see that my time is up. So unless there are no further questions, I'll rest on my brief, and thank you. Thank you.
No, hold on. I'm just going to check with the panel. Justice Rubin. No. Thank you very much for your argument. I'll return
Thank you for the
now.
opportunity. I appreciate it.
Very interesting.
Good morning, Catherine Sullivan for the Commonwealth. I'll jump right in here. I think the defendant's claims, the common thread of the defendant's claims rely on a view of the evidence in the light most favorable to the defendant. And unfortunately for him, we take a view of this court takes a view of the evidence in the light most favorable to the Commonwealth and considers whether or not there was a substantial risk of a miscarriage of justice.
Well, we do that for purposes of sufficiency, but for the purposes of a misinstruction, we apply a different standard, do we not?
Yeah, in a way. So there are a couple of cases that sort of come together and can be considered in assessing this question. One of them is Commonwealth versus Young, which is cited in my brief, and they lay out 4 different considerations for determining whether an erroneous instruction in that case on the law of defense of another created a substantial risk. One of the 4 of those considerations weigh in favor of the Commonwealth here. One, for example, is whether the correct instruction.
Are we talking about the marijuana charge now?
Yeah, yep,
Okay.
the first, yep. So the Commonwealth recognizes that the instruction was wrong. At the same time, I don't think it can be overstated that the defendant invited any error. So that is clear. It formed the basis for his theory throughout trial that he was only there to buy drugs. So it was a reasonably tactical decision on his part, but it's also clear in the end, and I'm jumping ahead of myself a little bit, but that the jury rejected that claim by finding him guilty of the breaking and entering. And to Justice Sullivan's earlier point, his intent could certainly be inferred from the breaking and entering, and that's pretty much well established. So the issue is whether the instruction itself caused a substantial risk. And Young lays out the considerations that this court looks at. Whether the correct instruction was in close proximity to the erroneous one, which in this case it was. Whether the judge repeatedly and clearly emphasized a correct instruction, which she did. whether the incorrect instruction was repeated by the prosecutor, which it was not. The prosecutor repeatedly emphasized that the Commonwealth's theory was stealing. And the judge repeatedly told the jury that stealing could be inferred from breaking and entering a household in the nighttime. And then whether the incorrect instruction was the last thing the jury heard, and it wasn't. So all of those things weigh in favor of there not being a substantial risk. There also is an interesting line of cases that's reflected by the case of Commonwealth versus Rodriguez, which is not in my brief, but which I sort of came upon in preparing for this argument. It's at 462 Mass 415, 2012. And in that case, the SJC affirmed the appeals court ruling that held that where the defendant had invited the error with an incorrect instruction, where there was evidence, where there was sufficient evidence of the greater crime, in this case, breaking and entering to commit a larceny, that an incorrect instruction on the lesser included crime, in this case, breaking and entering to commit a misdemeanor, did not create a substantial risk of a miscarriage of justice. So I would just alert the courts.
Wait a second, Rodriguez is the case about the incredibly complicated case about what is and isn't a lesser included offense, right?
It was about, reckless endangerment of a child and assault and battery.
Yeah.
Right.
Let's look at this case.
Okay. So I'm just.
So first of all, I want to ask about invited error.
Right.
Is there a doctrine in Massachusetts that invited error may not be reviewed, or do we do substantial risk analysis even if it's invited?
I think the cases vary, but usually this court does a substantial risk analysis.
Okay, because there is something kind of funny here where, right, there's always this tactical decision. Do I ask for lesser instruction or not? Because it'll be all or nothing. And so to some extent, the defendant gets the benefit. We don't say that jurors compromise, but the defendant gets the benefit of the lesser included offense instruction and then gets to argue, oh, and there is no lesser included offense. So I can see why that's problematic. On the other hand, at least in this case, and maybe you can explain this to me, the only misdemeanor the jury were told about were these non-misdemeanors. How can it not be a substantial risk of a miscarriage of justice? They weren't told that stealing less than $1,200 was a misdemeanor. They were told what's a felony. They're not lawyers. How are they supposed to know what a misdemeanor is? And right, they were told what the relevant misdemeanors were, and neither one was a misdemeanor.
Well, the misdemeanor wasn't explicitly defined for them, but the judge broadly defined misdemeanors as lesser offenses and that larceny over $1,200 was a felony.
Okay, so they weren't told, they were not told that anything was a misdemeanor except purchasing and possessing marijuana. That's the only thing they were told was a misdemeanor.
The judge also told them that lesser offenses, less serious offenses were
what do they know? How do they know what's a misdemeanor? How do they know it all? I don't understand. Your theory is that, and I don't want to put words in your mouth, is your theory that anyone would know, or an average lay juror would know, oh, they only were stealing $600, although they were in a building, which is itself a felony, but okay, I think that's the misdemeanor I'm thinking of. And then I have to say, in terms of substantial risk, we can't possibly know that that's what they thought, right? When they were instructed specifically there, these are two misdemeanors.
Right, and so my theory is that no substantial risk was created. That's my bottom line.
Someone of something that's not a crime is a substantial risk, right? Because it is a miscarriage. It's not just a risk. It is.
I'm sorry, I don't say it again.
Convicting someone of something that's not a crime is a miscarriage of justice, not a substantial risk.
There was more than sufficient evidence that the defendant broke and entered the.
Hold on, I just wanted to hear her answer.
Yeah, right.
Go ahead, please.
There was more than sufficient evidence that the defendant broke and entered the home in the nighttime with the intent to steal.
Okay, what misdemeanor is there evidence of?
I'm not saying that that's necessarily a misdemeanor, and I'm
Okay,
not
but
saying
that's
that.
the question, isn't it?
Well, let me ask the question differently. Can you say that, and I'm sorry to interrupt, can you say that it would have been sufficient for the jury to have found, or could they have found, that he intended to steal something? So just stealing something, is that what you're saying would have been sufficient under the analysis, that the Commonwealth was not required to say what that thing was? Fish oil, notebook, camping equipment, or whatever?
Yes,
Okay.
yes. And that intent, his intent was satisfied as to that crime when he broke and entered, because his intent to steal could be presumed from his actions. And the Commonwealth wasn't required to prove the amount of the item he sought to steal, and not required to prove that he did in fact commit that intended crime, the misdemeanor or the felony.
Could you give us, excuse me, just quickly, could you give me the site again to Rodriguez?
Yeah, it's 462 Mass 415. It's a 2012 case.
Got it. Thank you. Could he have been convicted on this evidence of the greater offense based on the inference from the breaking?
Yes, yes, and that's part of the reason why I think Rodriguez is important to that analysis. As the prosecutor repeatedly emphasized that they were proceeding on the theory of stealing.
Is there a lesser included offense of breaking and entering with intent to commit a misdemeanor?
I'm not sure. As you know, the panel discussed earlier, breaking and entering, I think, assumes the intent to steal in the nighttime. So
yeah.
I'm not sure breaking and entering in the daytime might be a lesser included.
No, it's different element.
Yeah. So I'm not sure. No. So I'd just be guessing here.
But my question, the reason I ask is, if we find that the instruction caused a substantial risk, ordinarily what we would say is, because of that element, there not being an instruction, a good instruction on that element, misdemeanor, ordinarily what we'd say is it's vacated or reversed and remanded either for a new trial should the Commonwealth choose to proceed, or for resentencing under whatever lesser included offense was found in the absence of that one element, right? That's what we usually do if there's a lesser included offense. Neither of you, though, has said that or asked for it. What do you want, if we find that conviction has to be reversed, what do you want us to do? What should our order look like?
I would assume it should look like that. It should be.
But what lesser included offense are we talking about?
I'm not sure. So I don't know. I haven't thought about that, frankly, because I don't think there's any doubt that there's a substantial risk, that there's not a substantial risk here based on applicable law. I mean,
okay, so what misdemeanor did the jury convict him of the intent to commit?
I think, in my opinion, I think the record reflects that the jury rejected the defendant's version of events completely and decided to come to a compromise on a less serious crime than the felony.
So we're supposed to assume that they failed to follow their oath and that they nullified the larger offense and came up with this. And so we're going to affirm on that ground?
There was a basis for their finding in terms of the judge's instruction that a misdemeanor was a less serious offense than a felony.
And what offense, which offense did they convict him of? Having the intent to commit?
Stealing, which I know is
stealing isn't a crime. What exact crime?
Well, the intent to steal.
Something.
Okay, I understand that. What misdemeanor did he have the intent to commit?
I'm not sure.
Well,
In this case, he intended his intent when he broke and entered was to steal. And I understand that that's not a misdemeanor. However, the jury's decision to find him guilty of the misdemeanor was likely a compromise to a less serious.
How can we affirm a compromise?
If I may, because there's a short amount of time, and I do have this question. Let's assume that the jury had to have found that he had the intent to steal when he entered, or they would have had to acquit. So they rejected his testimony on that basis. They could have also determined that he intended to steal and determined based on what they had taken, the cell phones and the fish oil, that they were petty thieves and not in there to clean out the family silver. The problem I am grappling with is that the judge all but instructed them that if you find he's a petty thief and not totally larcenous, I'm telling you here and now that possession of marijuana is a misdemeanor. How do we have any idea? And that's not a crime, which makes it distinguishable from Rodriguez, because Rodriguez was a case where the lesser included instruction was, to quote the SJC, a tactical decision that was far from manifestly unreasonable when made. How do we know what they considered when they decided that this was a misdemeanor? How do we know that they didn't rely on the erroneous instruction rather than the fish oil?
We don't, but there was a basis within the judge's instructions for them to find that the misdemeanor could account for taking items with a value of less than $1,200, and that it was a less serious offense than the felony, which they declined to find.
I agree.
I understand the problems with
completely
it.
For sufficiency purposes. I'm just struggling with an instruction that defines something that isn't a crime as a crime and saying that that's not a problem.
I guess overall, what I would say is the instructions are viewed as a whole. One erroneous portion of the instruction doesn't invalidate the whole entire instruction. She was adamant and repeated the instruction on stealing, distinguished between felony and misdemeanors. And although we don't know what the jury relied on, we can presume, or there is a basis for concluding that the jury could rely on the correct instructions and that no substantial risk resulted because of that.
Okay. Well, thank you very much. We had a lot of questions for both of you, and they were pointed at times, and that's important for us to really be able to get to the bottom of the issue. It's a very, very interesting case. We're going to take the case under advisement, but before we leave, on behalf of the panel, we want to wish you both a very, very healthy and safe new year. Is that the rules of appellate argument that apply in in-person arguments in the courthouse apply to this platform as well. So each side has 15 minutes. In this case, I understand that time is going to be divided between Attorney Jaspers and Attorney Beal, 8 minutes and 7 minutes each. There is no rebuttal in the appeals court, and you can be assured that we read everything that you provided to us, and so we're ready to hear the most important points of your argument. Second, and so far we've had good luck today, but upon occasion, we do have some technical difficulties. And if that happens, we will be patient with you, and we ask for you to be patient with us. So with that said, I'm going to call the case, and that is Department of Children and Families and another versus Father, 2020-0584. And one final reminder, the third reminder, I'm sure that you know that we are, of course, being viewed on a public platform as well. So the case is impounded, and so please do not use any names. All right. So Attorney Jaspers.
Your Honor, I believe the attorney for the father should go first. The appellant.
I have you down as for your first 8 minutes and for him for 7 minutes.
No, for the appellant is. That's how.
Oh, I am so sorry. I'm absolutely right. I got confused. You know what? The squares here are put me off. Thank you. And yes, I'm very sorry. Attorney Geary, you're the.
Good morning, Your Honor. Margaret Geary for the father. This is a fairly unusual case, and there isn't an awful lot of law in it. It's mostly a factual issue in terms of the standard. I'm getting an echo. I wonder where that's coming from.
Do you have your YouTube channel open?
I don't believe so. Let me check. that puts the child's well-being much at hazard. And the other standard is that the parent has to be a minimally acceptable parent. We have a father here who is parenting another child out of state who passed from, I understand the judge found that he didn't complete his interstate compact, but there's other evidence that he did. He has a good job. He's raising another child. And for most of the case, the department didn't have any complaints about him. And the judge's findings don't reflect that, and they don't reflect it for a variety of reasons, and I'm not sure what those reasons are. It does appear that the judge didn't look at the court investigator reports. It seems as if she didn't look at most of the documentary evidence. Now, at whose door that problem should be laid is a separate issue. Obviously, the duty of the father's attorney would have been to marshal all of the positive evidence that was in the record, so that the judge would have been able to see that, no, contrary to what the witness testified, the father did in fact complete his interstate compact.
Well,
No.
I'd like to stop you right there, because there's a couple of issues related to the interstate compact. And let me deal with the factual one first. The father testified and the social worker testified that he received initial approval from the state of Connecticut. No one put any of the written documents from the state of Connecticut in the record, which hampers our review significantly, but be that as it may. The social worker then testified that they had additional questions and asked the state of Connecticut to perform further investigation, including investigation into his history of domestic violence with his current partner and an interview of the partner. At that point, the evidence diverges. The father says he cooperated fully. The social worker, however, testified, and I'm looking at volume 1, page 211 of the appendix, that it did not receive any further information from the state of Connecticut, and that he refused to follow up with the state of Connecticut to permit their additional questions to be answered. Is that testimony in and of itself not enough for the judge to make her finding that there was an initial approval but not a final approval?
Well, first of all, it's very difficult to get interstate compact records in. They tend to be not business records because they were an evaluation of the parties. And unless the state of Connecticut wanted to cooperate with counsel, they couldn't realistically be subpoenaed to come in and testify. So typically what I see is that we get the yay or the nay, but we don't always get the detail coming in. It would have been nice to have the court investigator contacted them. Again, it didn't happen. Secondly, the person who was testifying—
the social worker testified that she had an email from the state, but I suppose it could have been met by hearsay objections. But I appreciate your explanation. Thank you.
But it wasn't the social worker who was testifying. That's the other problem here. It was the social work supervisor who was testifying.
Understood.
And in my brief, I do point to the exact space in the record where the social worker, Sarah DiNapoli, acknowledges that father did in fact complete all of the extra work that needed to be done on this case.
And are you talking about the court investigator report or the social worker's testimony?
The social work supervisor was the only one who testified, and the social worker met with the court investigator. So that there's a divergence in the testimony there. I guess it would have been appropriate for the judge to weigh who would know more, the social work supervisor or the social worker who presumably had been working with the family since the beginning.
But when you refer to the social worker, you're referring to the court investigator report, correct?
Sarah DiNapoli interviewed by the court investigator. Yes, that's correct.
So here's my question about the court investigator report. That report was not admitted into evidence, was it?
It was not, and there are two cases.
If I could just finish and put the whole question out there so you'll understand where my concerns are from. There is, however, an entry on the docket that January 2019 final court investigator report, and indeed all of the previous court investigator reports, were entered on the record. So what is that act, and what relationship does that bear to whether or not it's in evidence in the case?
The statute says it will be on the record. So I don't know what that means. I haven't seen any case law to that point. But what I think historically it has meant is that it's there and that people can use it. There is the case custody of 2 minors, which I cited, that indicates that it is there and it can be used. And then there's it's there for the judge to use in evaluating the case. I mean, that's the whole point, that there's a court investigator to marshal the evidence for the judge to review. And the statute says that the court investigation report is on the record.
Now, but adoption of errand says that unless it's entered into evidence, the parties aren't on notice that it's going to be used in the formal adjudicatory hearing rather than pretrial proceedings. And that therefore it's a problem. I mean, Aaron seems to suggest that from the father's perspective, the court investigator report doesn't exist unless it's entered into evidence.
What Aaron says is in dicta, because it says, well, we would have to address that if we weren't disposing of this case on other grounds, first of all. Secondly, Aaron was protective of the father in that I presume there was negative information in the court investigation report that the judge considered and held it against the father. The father is not arguing at this point that he was in any way prejudiced by the fact that nobody called the court investigation report to the judge's attention.
Right, but the department and the children might have been. So the question is, does the rule go both ways? And a further question is, does it matter that this was on review and redetermination? Does that in any way impact the analysis in Aaron?
Well, the department's burden is the same once the initial, it was the department who was asking for a termination of parental rights. So in that sense, I don't think it has any impact on the burden. And Aaron itself says that for all intents and purposes, there isn't any change in the burden. And if there were, I would argue that father's compliance with the interstate compact would have been a sufficient change in his circumstances to shift the burden back to the department in this particular case. So I don't think.
Remember, does the court investigator report say when she talked to the social worker, whether it was before or after the additional questions were posed?
I think I figured out it had to have been in December of 2018. I had to, when did the court investigator report do his job? When did the court investigator report come in? So I think the interview occurred in December 2018, just extrapolating from the context. And the statements relating to he didn't complete his court investigation report, his interstate compact, were made by the supervisor 5 or 6 months later. It does seem to me that if the social worker would be a person who would have firsthand knowledge of this, as opposed to a social work supervisor who is coming in.
So let's say we conclude that the trial counsel may have erred here in not pointing to this stuff, not calling the other social worker, although of course these could have been tactical decisions. If we conclude that without it being entered as an exhibit, it's not in the record for purposes of our review, is that the end of the matter?
Well, no. Because there's a set of facts here, and how you choose to characterize the facts, I suppose, determines what action would need to be taken. If there's substantial positive information in the court investigator reports, and it was incumbent upon defense counsel to see that they were admitted, then we would have an ineffective assistance type of situation.
But you'd have to bring that in the first instance in the trial court, wouldn't you?
Unless
we don't know what the tactics of this, right? We don't know if this was a tactical decision or an oversight or a complete failure or what it was, right?
I think it's manifest on the record, Your Honor, that there was nothing particularly negative about the father in those court investigation reports.
Well, he didn't participate in the court investigation, right?
He did not.
Did he refuse to speak to the investigator?
I don't have that information.
It doesn't tell us in the report itself. I remember reading that he didn't participate, but I wasn't sure why.
I can't answer that question. It may be that it's in there or not. I don't have any particular recollection of it. Sometimes I tell my clients, you know, the burden of proof is on the department, and your failure or not to cooperate with the court investigation really doesn't have any impact on, or shouldn't have any impact on, how the evidence is weighed, because it's really not your burden to prove that you're a fit parent by sitting down with the investigator. And sometimes that's a reasonable tactical decision if you have a client who tends to open his or her mouth and insert their foot. I don't know.
right,
I had a tactical decision as the appellate attorney to make here, and after reviewing the case law, it was my impression, based on the court investigators' reports, based on a lot of the exhibits, I can't see that the judge looked at them. The judge is required to look at the record of the case before making a decision. That's one of the fail-safes that we have. Maybe we don't have zealous advocacy, the kind of zealous advocacy we would like to see in every instance in these cases. But if the judge had just looked, let's lay aside the court investigation reports, even if she had just looked, she would have seen contradictions to a lot of the testimony given by the...
It is still an adversary system. And in closing, trial counsel did not say, you know, look at this stuff, or that's so overstated what the person said, because the actual on the ground social worker said the opposite, or anything, you know.
I absolutely agree. And when this court was confronted with a similar situation years ago in adoption of Flora, this court did find that because there would be manifest injustice to the father or to the child in that instance, if relief wasn't granted, that it would in fact be appropriate to grant relief. And when you can see ineffective assistance on the record that's brought before you, if you choose to characterize it that way, then you can act.
counsel, correct me if I'm wrong. Is there an ineffective assistance argument made in your brief?
See, there is not.
Okay, let's move on then. Do you dispute, is it true, or do you dispute on this record that the father had made only 4 visits in a 1-year period of time preceding?
I cannot tell. I think he did not make all the visits that he was supposed to make. I think that's a fair determination from this record.
Let me ask the question differently then. Is the judge's finding that he only visited 4 times between June 2018 and May 2019 clearly erroneous?
No, but then the question becomes, what do we take from that, given that father's a truck driver who lives a 4-hour round trip from where he's supposed to visit with his daughter? What do we make?
How long ago did he stipulate to his own unfitness?
It was in 2016.
And when was the child taken from the mother?
Pretty much at birth, which was in 2013.
So for the 5 years leading up to the trial, first he didn't, when the mother was not fit, he didn't step in to take her care for the child. And then eventually, after several years, he acknowledged his own unfitness, right?
Yes, he didn't step in. The mother was in fact given placement or custody right after the removal of the child, and she was directed, I believe, up to a shelter on the North Shore, which is a significant.
But if he was out of state, but he lived somewhere, and he didn't come to get the child or say, oh, the mother doesn't have a house for her, she can stay with me, or anything like that.
That did not happen. That's correct. And I believe there's even an acknowledgement that at one point when he was much younger, he didn't have the financial resources to care for her.
And then he stipulates, and under the redetermination rule, your time's expired, but I guess I do have a question, which is he has to show a change of circumstance. The court is allowed to take into account the earlier stipulation. It's a redetermination. What changed exactly between the time of his stipulation and trial, that means that the DCF can no longer meet its burden? What is the change?
He has a very well-paying job. He has a stable place to live. And if you believe, if the court investigation report comes in, he did exactly what he needed to do to make sure that she could be placed with him.
He had a job before that, right? And I don't remember where he moved
He
to
did.
first.
He was working
So he's had a
service
job the whole time. So that's not new. He does have a girlfriend in a house, so DCF has never heard of them, heard of the talk to the girlfriend. We have testimony that he didn't complete the ICPC, and we can't even tell that social worker Napoli would disagree with that. And then he visits this kid 4 times in a year, and he's entitled to either 12 or 44 visits. Either way, it's a pretty sorry record. You think that change is adequate so that the burden of clear and convincing evidence that he's unfit can't be met here on this record?
Yes, of course I do. And I don't believe that Sarah Napoli would say he didn't complete his interstate compact.
We don't know what day because, right, you said she testified 5 months later, but we don't know what date this additional work from Connecticut was supposed to be completed. We don't know if it was after or before December of 2018, do we?
We actually do, because there was a notation that after the interstate compact was completed, the department met and decided that because of the father's inconsistent visitation, they were not going to reunify with him. It's in my brief. I can't, my eyesight is too bad for me to locate it for you right this minute. It's in there. It happened sometime between February of 2018 and October of 2018. And I think the department acknowledges, and not necessarily in the court investigation report, that they had that information and that they made a decision based on something else besides that.
I understand that, but I didn't ask you that. I asked you if we know when he failed to cooperate or didn't fail to cooperate with Connecticut after DCF went back to Connecticut. Do we know what day DCF asked Connecticut to do further investigation? And do we know what day Connecticut responded to that request?
We know that it was before February of 2018.
Okay.
Based on the documentary record.
Very good.
All right. So your time is up. Thank you for answering our additional questions. I'm just going to check with the panel, and I see no more questions. Again, I apologize for not calling you first. That was inadvertent on my part. So now we'll turn to the attorney Jaspers.
May it please the court, Adelaida Jaspers for the appellee, the Department of Children and Families. In this case, the court's findings and the evidence which the court even-handedly weighed demonstrate father's parental deficits as shown by his domestic violence relationship with mother, which went unaddressed, and coupled with a pattern of parental indifference as reflected by his repeated failure to be part of the child's life at any significant crossroads, his inconsistent contact with the child, his failure to meaningfully engage in services, and lack of insight into her needs, all factors that contributed to the finding of his unfitness into the indefinite future, which was supported by the clear and convincing standard of the evidence. If I may first address the question regarding the court investigative report. The father received notice of the court investigation report, and he had the opportunity at trial to offer them into the evidence, call the author of the report as a witness and cross-examine him, but father failed to do so. In addition, the court's weighing of the evidence is entitled to substantial deference, and as such, the court was not bound by the court investigative report and could rely on other evidence. This is especially so when the information contained in those reports in aggregate was not more favorable to the court's, to the father's case, and it would not have changed the calculus of the court's determination. And
could you answer my question about what it means to enter the court investigator report on the record and what the difference is between that and admitting it into evidence in the hearing?
To admit the court investigator report into the record, Your Honor?
Yes, it was admitted into the record. It's on the docket.
Mhm.
That it was, that it was, here, let me, I just had it. It was placed in the record.
That's correct, Your Honor. And it
Does
is.
that mean that it's available at hearing, or does it have to be, what does that mean? Does it?
It means that it's available, Your Honor. The statute 11924 states that a court investigator report is part of the record. And the case law, one case in particular, care and protection of Zeta, also notes that a court investigator report is part of the record as well.
So does that mean it should be treated as if it were an exhibited hearing?
Again, Your Honor, as I mentioned, father had the opportunity to introduce it into trial, but also the court was.
But did he have to? If it's in the record, is it already effectively there for the judge's consideration?
The father perhaps did not have to, but the father had the opportunity to call the author and cross-examine if there were any.
I understand that. That's not my question. That he could have, certainly, and so could the department, frankly.
Mm-hmm.
But you know, we're left with these vagaries of people testifying third hand to what Connecticut did, and we have to deal with that. So I am trying to resolve what appears to be a conflict between the notion that this can be made part of the record and adoption of Aaron that says you have to admit it into evidence. And I was hoping you could explain to me how I can fit those things together.
The better practice, Your Honor, is to admit it into the evidence and mark that as an exhibit, which father did not do so here. But
Nor did the department.
Nor did the department. But also importantly in this case is the fact that the information contained in those reports would not have changed the outcome of the case, because the court investigator report, especially the most recent one, which reflects the most recent evidence, showed that father had not complied with services and he had not participated in visits. So the department at the time was concerned of his lack of attention to the case and the child as well.
So you think that the judge could have considered the court investigator report and that it was in the record?
The judge could have, and there is no indication here that the judge did not, but the judge was not bound by the court investigator's reports.
The judge could rely on the testimony versus the secondhand report and the investigator report, although the testimony was also secondhand, but nobody called the primary witnesses.
That's correct, Your Honor. And again, their father, as Justice Rubin mentioned, had the opportunity to call the social worker, but father did not avail himself of that opportunity.
But the judge didn't reference anything from the court investigator's report either.
The judge did not, Your Honor.
And it seems like some of it is contrary to the evidence that was presented at trial.
Well, the salient evidence and the most recent evidence that the court was bound to consider is consistent with the court's findings. And that is that father did not participate in visits, as I mentioned, especially in the last year, in the year leading to trial, when he only visited 4 times, but he had the opportunity to visit 44 times or 12 times. In either case, that's a very low rate of visitation. And this court in adoption of Wren stated that a parent's lack of visitation is indicative of a parental unfitness. Father's indifference to the child's case and the child also is shown by the fact that after the department's removal of the child from mother's care, father did not make himself available until February 2015, which was 6 months after. And also Even after father stipulated to his unfitness in 2016, he did not make any meaningful changes to show appreciable gains and did not improve his parental shortcomings. Finally, after determining that father was unfit to parent into the indefinite future, the court was bound to view the best interest of the child. And in this case, the evidence shows that the child has been in the care of the pre-adoptive parents since she was 4 months old, has forged a positive relationship with them, and that she has thrived in their care. Therefore, it was in the best interest of the child to terminate parental unfitness. In some, the court should—
If I may, because your time is running out. With respect to the allegations of domestic violence, the judge refers to the 51A report. In your view, do the 51B reports in evidence substantiate the existence of domestic violence between the mother and the father?
Absolutely, Your Honor. That it was the evidence shows that in August 2013, they engaged in a physical altercation in front of the older child, which culminated with father slamming mother into the ground.
Do we have a police report of that? I saw the police report about the harassing texts, but I didn't see a police report for that incident, but there were hundreds of pages of police reports.
I don't believe we have a police report regarding that specific incident, Your Honor.
Okay, that's all I have.
Thank you. I think my time has expired, and if there are no further questions, I would like to rest on my brief.
Yes, I'll check with the panel, and I don't see any. So thank you very much for your argument, and we'll turn now to Attorney Beal.
May it please the court, Eric Beal on behalf of the appellee child. The evidence I submit was sufficient in this matter to support the court's termination decree. And taking sort of an overview of the evidence, there was very substantial evidence that the father did not avail of himself to create a relationship with his child, and through the failure of visitation that's been discussed, but also through other parts of a service plan that he did not follow through on. And for example, medical and dental appointments, contacting service providers for the child. And he also didn't cooperate with assessments, sign releases, or regularly meet with a social worker or engage in counseling. These are all items that are on a service plan and opportunities for him to demonstrate his parental ability. And he failed to avail himself of those. So I do submit that the evidence was sufficient. With respect to the ICPC, that was one item on the service plan. The evidence, it sounds, as you've heard, that it was not as complete as it might have been. However, the social worker's testimony was that, in the court's finding, was that the father did not follow through with what was required to complete that process. With respect to the best interest analysis, again, the court found that father, during the 4+ years that this case was open, simply didn't take the steps necessary to demonstrate that it would be in child's best interest to be reunified with him. At the same time, the court found very substantial bonds between the child and the pre-adoptive family, whom she refers to as mom and dad. And this pre-adoptive family wishes to adopt the child, and that's the child's intention, is also to remain with this family. Certainly the court was required to evaluate the proposed adoption plan, and it did in this case find that it would be in the child's best interest for adoption to be pursued. With respect to father's argument related to adoption of Catherine, I submit that case is distinguishable. And the father's argument being that if the relationship with the pre-adoptive family was quote, the decisive factor, then there would be some additional elements of proof. In adoption of Catherine, this court found that, in fact, the parents in that case, who admittedly had been using cocaine, but the court found that there was no evidence in the trial court's findings in Catherine to show unfitness. And by contrast here, again, there's, I think, very substantial evidence of unfitness.
I'm sorry to interrupt you.
Yes, Your Honor.
Have we just lost counsel for the father?
Yeah.
I no longer see her on my screen.
We're live.
Okay, thank you very much. Well, listen, as you have seen that we were interrupted, that attorney Geary for the father was, her screen disappeared. Was noticed by Justice Rubin. The clerk's office has reached out to her. Apparently she has lost power from where she was participating in her oral argument. She was doing so out from Athol, which is a small town out in Western Massachusetts. In any event, she has indicated that she has an agreement for us to continue the oral argument without her being present. As we know, this of course is recorded, so at a later point in time, she can view the arguments and see what else was said. At the time that we recognized this, Attorney Beal, you had about 4 minutes left of your argument. I know it's difficult to pick up again after an interruption, so we understand that. I do also want to say that we did offer to Attorney Geary whether or not we could get on with her for via telephone or some other method, and she did not respond at that point. But given the fact that her power was out, just as likely that she did not have notice of our further efforts in that regard. Okay, so we're going to continue on, and Attorney Beal, the timer will come up with 4 more minutes on your behalf, and we're interested in the rest of your argument.
Thank you, Your Honor. I was discussing the application of adoption of Catherine. Again, in that case, the trial court had not made findings of unfitness and remanded the matter. This case is distinguishable because the court did make significant findings of unfitness for father. And I think, the last point I would make is further evidence of father's lack of involvement with the child here. The evidence was that there was no close bond between the child and father. That's Record Appendix Volume 1 at pages 212 and 220. And there's nothing to contradict that evidence of a lack of bond. And whereas there was, again, a very significant bond formed with the pre-adoptive family with whom the child has lived since she was an infant. I have nothing further. Unless the court has any questions for me, I would rest on my brief.
When was the last time you spoke with your actual client?
During the pandemic, I've been keeping in contact with my child clients via Zoom, and it was around Thanksgiving, Your Honor.
Okay. And there's no change. I mean, I know it's outside the record, but there's no change of circumstance with respect to her placement or wishes or anything of which. It is outside the record, Your Honor, and I'm not aware of anything having been filed that there was any change in the circumstances or anything in the record after the trial that would suggest that this placement has changed. Is there something outside of the record that suggests that the placement?
No, Your Honor, no.
Okay. Very good. Thank you.
All right, well, thank you very much. I see there's no further questions for you, Attorney Beal, and I want to thank you both again for your patience. These glitches don't happen often. When they do, they're disruptive, but we get through them. So thank you very much. And also on behalf of the panel, I want to tell you and Attorney Geary, when she does listen to this later on, that we wish you all a very safe and a very healthy new year.
We're live.
Thank you very much. All right, good morning, Attorney Whittegren. Did I pronounce that correctly?
Yes, thank you.
I'm going to call the case officially. This is the case of Raymond Thatcher Jr. versus Laura Thatcher, 2020-0293. We have appearing before us today only you on behalf of Raymond Thatcher. No one is appearing on behalf of Laura Thatcher, nor is she appearing for herself, and she has not filed a brief. Just briefly, Attorney Whittegren, just so you know, my name is Ariane Vuono, and I'm joined today by Justice Peter Rubin and Justice Mary Sullivan, who will be the panel hearing your case today. You have 15 minutes to present your argument. We've read your brief and all of the information that you've given us, so you can get right to your most important point. And lastly, although I don't want to jinx it. We do sometimes have some technical difficulties, and if we do, we'll be patient with you. We hope that you're patient with us. All that said, please go ahead and begin your argument.
Thank you. If it please the court, good morning or good afternoon. I could start by saying that the Alimony Reform Act was a tremendous change in the divorce law. It allowed for the ability to essentially almost go back in time and modify long-standing orders involving the duration of an obligation to pay alimony. It's also, for the first time with regard to alimony, established a way to calculate an alimony payment amount, which I would suggest helps to ensure that similar cases are treated similarly. I've been representing parties in divorce cases for 38 years. And in my opinion, the Alimony Reform Act codified a long overdue increase in the fair and consistent alimony orders and process by which to ensure that result. I believe, I propose that in this case, Mr. Thatcher was neither given the full benefit of the Alimony Reform Act that he was entitled to, or at a minimum, he was not given an adequate explanation as to how it was applied in his case. In July of 2002, after a marriage of approximately 19 years, Mr. Thatcher, then 40 years old, was ordered to pay alimony to his 39-year-old wife for as long as possibly the rest of his life. Under the circumstances of this case, Mr. Thatcher would have had no realistic likelihood of ever, without either of the parties dying, being unable to stop making those payments until the passage of the Alimony Reform Act. So I'd like to start by, with the issue that I raised secondly in my brief. I know I have limited time, and I think it's the more essential issue.
It's the calculation of the alimony amount.
Yeah. I mean, the court below made a number of factual findings, but with virtually no explanation for how those findings, factual findings, led to the specific findings necessary to apply the new law. It's new law to me anyway, kind of, and making its judgment. A prime example, just one example, but a prime example of this is the court's finding that Mr. Thatcher made deposits of $143,512.76 in his TD Bank business account, but with no explanation as to what period of time or why that was a fact used by the court in making its alimony determination. The court points out that he had received $50,000 in gifts from his parents over a period of years. Is that included in the $143,000? Is the court below specifically including the gifts in determining Mr. Thatcher's income for purposes of calculating an alimony payment? There's simply no way to tell from the way the judgment was written. Mr. Thatcher testified specifically regarding the year 2019 that some of his deposits were $20,000 of gifts from his mother. Some of it was proceeds from the sale of a boat, and some of it was a transfer from a personal account necessitated by the fact that there wasn't enough in the business account to pay the business expenses. The statute dealing with calculating alimony does specify what's to be included in income for purposes of calculating alimony, including in the court's judgment below that the husband received $50,000 in gifts from his parents without further comment implies that the court was including those payments in calculating the husband's income without specifically saying whether it did or it didn't. If so, I respectfully suggest it should be inappropriate to do so, given the definition of income that is contained in the law. If you include all of the money husband reported on his financial statement, filed under oath in this matter, his average grossly income was $689. And in his financial statement, he included money from his parents. He included money from other things. But even assuming all of those things, and we're certainly arguing that the gifts from his parents and the sale of his boat and transfers from his personal assets into the business account should not be included. But even if you include all those numbers, his gross weekly income comes out to $689 a week. If you apply the higher percentage of 35% contained in Chapter 208 53B, at least to an alimony of $241 a week. The current order of $300.
Oh, but wait. This is a question I had. So tell me why I'm wrong about it working the following way. So they have either, I don't know if it was originally an agreement or after trial, a court order that says pay alimony this amount until someone remarries or dies, okay? There's now a durational limit, and the judge found, and we've sort of skipped over that, but we understand your arguments about it, I'm sure. The judge finds the durational limit should not apply. Okay, but still you've asked for modification, and there's actually a counterclaim for modification the other direction of the amount. So I gather you have to show changed circumstance, and you would then have to show, and then the question will be, does the wife still have the need? Does the husband still have the ability to pay? I don't see why that 30 to 35% safe harbor comes into it at all, because this is now we're just talking about modification of a court order. Do you see what I mean?
I do, and I perhaps I've misunderstood the Alimony Reform Act, because it was my understanding that once you have established that you've gone beyond the durational limit, the entire statute applies. It specifically states, for example, that what's not included is the ability to terminate your alimony if you reach a retirement age. But my interpretation of it is that the new ability to calculate child's alimony in a similar manner to which they calculated child support is a huge benefit to everyone, all the parties. And I thought that my understanding of the law was the only thing you have to establish by way of modification or change in circumstances is the durational limit.
Well, but okay, so okay. So the answer to your question, my question is, you think I'm wrong, and I may well be, because there's only one case, or I think only one real case on this so far. But I had thought that the question of, do we get rid of the durational limit, that barring some other change in circumstance, be like, so we got rid of the durational limit. The order continues absent a basis for a change. If I'm right about that, is there a changed circumstance here? And is your argument, I take it your argument focusing on income is about ability to pay, or is your whole argument that it should be within this 30 to 35% range?
Well, assuming that I'm wrong, which is certainly possible, and that you're right, and that, if I understand your question, you're saying I should assume that for now, for purposes of discussion, that the 30 to 35% new portion of the Alimony Reform Act does not apply.
No, I'm asking, well, okay, maybe with changed circumstances.
You actually made an allegation. You actually made an allegation that there was a change in circumstances, that your client makes less money now.
Right. So I was going to say, assuming, I believe that the 30 to 35% should apply, period. Once you've reached the durational limit thing, it's hard to call it the durational limit thing, but
we understand.
But even without that, I've certainly have had many cases over the years where the trial courts have said, I'm going to dismiss this case outright because you haven't proved a change in circumstances. We don't need to have a trial because you're not even, I've seen complaints where you weren't even alleging a change in circumstances. But in this case, assuming that you don't have, the court's not required to apply the 30 to 35% percentage, you still have a change in circumstances based upon at least the husband's change in circumstances financially.
Okay, now he says the price of cranberries has dropped from 2017 highs. The court says, yeah, but the cranberries you get much more for cranberries now than you did in 2002. He says, yes, but I am now self-employed and have all these expenses. And so I don't understand how we're using the word gross here, so I'm going to use the word net. My net income is dramatically less than it was in 2002.
Yeah.
In fact, if you look at his sheets, he says, I make I have $171 a week or something left after all my expenses, right? Some 160, 170, I don't remember. Now, the judge didn't say, I suppose she could have, I don't find those to be reasonable expenses, and therefore I don't believe this. I'm looking at your tax returns, which show substantially more income than 2002. I'm looking at your deposits, which you say they come from this or that, but it certainly shows a throughput. I understand you could then have to pay expenses from it of X, and so I disbelieve it. But she didn't say all that. Is that your objection here? I mean, I'm not saying that's a minor objection. She didn't say, I reject those expenses as not reasonable. I don't think that she really shows, I mean, maybe she implicitly did that. I don't know, I have to look more closely, but that's the problem, right?
Well, that is certainly a significant problem in the case. I mean, even from a standpoint of you know, the judicial system, I mean, we depend upon a court issuing a judgment to make its judgment clear enough that we don't make the mistake the next 5 times. You know, I mean, obviously we depend significantly on appeal court decisions because you clarify so many things about laws. But even at the trial stage, you know, we need a court to be, and I think a client should be entitled to enough of an explanation that perhaps he's advised, you know, it's not worth making an appeal because it's so clear that you would just be wasting your money. But there's so little explanation in this case. I mean, she could have said, like I said, I've had other cases in the past where the court says, oh, you just haven't met your burden for change in circumstances, case dismissed. She never says that. She talks specifically about certain changes in income, changes in expenses. So she brings those topics up, but never suggests that it doesn't matter because, you know, it just doesn't matter under these circumstances.
Well,
I mean, I've asked for different kinds of relief, but at least I would request the relief that she be required to explain what she did and why. I think that's
she did say that the need continues, and that doesn't strike me as a clear error or, I mean, it's a woman living in her car. It's a bad situation, obviously. And she also found continued ability to pay. Why is that not enough?
Well, because even under the prior law, you could show a different ability to play. You could demonstrate a different ability to pay and seek a modification. I mean, even before the statute was put into effect, the new statute, if somebody became disabled, if somebody was paying alimony and became disabled and could no longer pay that much money, I wouldn't think there was no reason under the prior law they couldn't seek a modification. In this case, he's presented scads and scads of paperwork and bank statements and tax returns and solid, undisputed evidence of the fact that even if they are paying more for cranberries, the cost of picking cranberries has gone up so much that you asked the difference between net income and gross income.
I mean, it's a tricky point, really. His taxable income is dramatically higher than it was 20 years ago.
But a self-employed person's taxable income is based upon his net business income.
Mm-hmm.
That's been standard procedure for child support and alimony forever.
Of course.
So
two questions. Is this a subchapter S corporation or is it separately? Only separate?
I don't believe it's a corporation at all.
You think he's just a sole proprietorship?
I believe so.
Okay. And is the judge permitted to say, look, your net income is down, but she's living in her car and I'm not changing the alimony award?
I don't see how the law allows for that. I mean,
well, she did say, if I'm going to interrupt, following up on Judge Sullivan, the judge did explain this and said that it was up to the former wife here to prove by preponderance of the evidence that the alimony was in the interest of justice. having already found that your client was in excess of the durational limits. So following Justice Sullivan's point, could the judge, was there sufficient evidence here for the judge to have found that in the interest of justice, alimony was necessary? Before we go to your second point, which is what was the appropriate amount?
Well, my client takes a position in the brief that there wasn't sufficient evidence because all of the evidence regarding her disability and her medical issues was based upon her testimony. There's no independent evidence whatsoever.
Was there any real dispute with respect to the various physical medical challenges that she has, that she testified to?
Well, let's say that's certainly consistent with the conditions that she was found to have in 2002 on the date of the divorce. It's consistent with that. But even if you're going to look at the testimony and if you're going to look at it from that standpoint, I mean, it's difficult for me to sit here, normally stand here, and say that somebody can live on $160 a week. But, you know, that's what she said she lives on. I mean, I don't want to argue that she, I don't want to argue that she does. My client feels—
No, because there wasn't even an allotment for food or other things in what she stated. I actually, sorry to interrupt you, I actually think we may have a problem with our timer because I see we've gone back to 14 minutes and I think that you were close to the end of your argument when I started asking, yes, your time is expired, when I started asking you questions. So I'm not gonna, I want you to have an opportunity to sum up. And before you do, did I cut off Justice Sullivan or Justice Rubin with any further questions? No. So why don't you sum up and
Thank you. I think that I take the position, or we take the position, that in the circumstances that occurred in this case, the trial court can't simply say, no, you can't have either a termination or a reduction in alimony you've been paying for 18 years, and we're not going to apply the guidelines to determine whether you might be entitled to reduction in income. And since under the Alimony Reform Act, the husband's reaching a statutory age does not serve as a basis for terminating alimony, how does a person such as Mr. Thatcher, who earns his living in the only way he's ever earned it, by physical labor, and what he calls, how does he get relief from what he calls a life sentence of alimony payments? I mean, what does he do from here? If this judgment is upheld and he can't take advantage of the statute that says, well, if you reach your retirement age, you can come back and we'll reduce or eliminate your alimony. I mean, you know, there's the issue of, you know, Knox and the issue of what's in the interest of justice, but arguably, where's the concept of justice for him? How does he ever end paying child support if he doesn't get the benefit of the statute?
I think we see your point, and thank you for your summation there. We will carefully consider the issues and get back to you with a response as soon as possible. Meanwhile, on behalf of the panel, we all want to wish you a very safe and very healthy new year.
Thank you very much, sincerely.
We're live.
Thank you very much. All right, good afternoon. I'm going to call the case Karen Monteiro versus Peter Clark and another, 2019-0641. Attorney Frizzoli, let me introduce the panel to you. My name is Ariane Vuono. I'm joined today by Justice Peter Rubin and Justice Mary Sullivan, and we will be the panel hearing your case today. You're the only one appearing. We have only the appellant appearing today for argument. The appellee will not be appearing, and there's been no appellee brief filed or expected in this case. Just so you know, of course, you have 15 minutes to present your argument. Same rules of appellate argument apply. And just so you know, we've read everything you've submitted to us, so you can get right to your most important points. And finally, we've had a couple of problems so far today, a few glitches. We were able to overcome them, but if we do have any technical problems, please be patient with us. We'll be patient with you. So with that preamble over, please begin your argument.
May it please the court. Good Good morning, Your Honors. My name is Charlie Frizzoli, and I represent the plaintiff appellant Joan Stormo in this case. On appeal before you today is the question of whether or not the plaintiff is entitled to her costs associated with the litigation of her legal malpractice in 93A claims against the defendant. After the trial judge's 93A decision, which was in favor of the plaintiff and awarded her treble damages against the defendant, the plaintiff moved for attorney's fees and costs for the litigation. After the motion hearing, which was opposed and argued by the defendant, the court allowed the motion for legal fees and gave the plaintiff's attorney 100% of legal fees while stating that the case was a complex legal malpractice action. However, in the ruling of the motion, the judge did not rule one way or another if the plaintiff should be awarded her costs for the litigation, and therefore she was awarded $0 for that. There's three costs that I bring up in my brief. The first being the expert witness fees, the second being the deposition costs, and the third being the statutory costs in relation to filing the litigation. There's actually two standards of reviews across the three of them. For the expert witness fees and for the deposition costs, that's to review an abuse of discretion if the trial judge disputes her discretion by not awarding those fees. And the third fee, the statutory cost, is actually a de novo review. So that will be a review from the appeals court to remand down to the trial court. Starting with the expert witness fees, for the trial, the plaintiff hired an expert witness, the former head of the Board of Bar Counselors for Massachusetts, to testify and give expert testimony at trial. This expert testimony was essential to our 93 claims and malpractice claims. Because
can I just ask very, very briefly, since she didn't reach this in what looks to me at least like an oversight, although you say it wasn't an abuse of discretion, how do we know what amount was reasonable? Shouldn't we just send it back and let her figure it out?
That's certainly a possibility, Your Honor.
I mean, I just don't know how to tell. I wasn't there at the trial. How do I know how much expert witness fee, or you know what I mean? I mean, this is pretty small money given the whole thing, but still.
Yep, and I agree with Your Honor, and that's certainly a possibility that we would be open to.
Was there a motion to reconsider? Was there any other after you received the award of attorney's fees and treble damages and an amount of $0 with respect to your other costs? What happened then?
So there was no motion to reconsider. The way it was left was that the defendant had asked to bring in his own expert to contest the legal fees, and he never followed through with his request and never filed any opposition. So the judge just ruled on the hearing the papers at that point.
And so, but the judge issued, there's an appealable judgment here with respect to costs that was entered after the time had elapsed that the other party was given. Is that right?
Yes, Your Honor.
Okay.
Am I correct? Do we have, and forgive me if I've overlooked it, do we have the trial transcript?
There's portions of the trial transcript that are relevant in the...
That I saw, but following on Justice Rubin's question, the award of expert witness fees under Rule 93A, as you have pointed out, and I assume you're relying on 93A for this, not 54D, is discretionary, and the fees have to be reasonable, and there has to be a demonstration that the testimony is related to the 93A claim rather than the malpractice claim. And I assume that the witness also testified with respect to the malpractice claim. And it's quintessentially, I mean, it's possible that the judge determined that she thought that the witness was more relevant to the malpractice claim than the 93A claim, but it's a little hard for us to tell.
Yeah, and even with that point, you know, let's assume that she decided not to award them. That's why, you know, we brought this appeal, you know, stating that the testimony was in fact important to both the malpractice and the 93A case as they were intertwined under the same action.
But if it also is related to the malpractice claim, are you automatically entitled to the full amount of the expert fee, or would there be an apportionment?
So looking at the statute or in the case law, it is just for the 93A portion, so that would kind of make the difference. So I agree with that.
We've seen these cases before where judges apportion fees, they apportion costs. And it's frankly difficult for us to assess without having, I appreciate that you gave us portions of it, but there are times when that leaves us wondering what else was there. So we don't have, so it's a complicated case in its way.
Mm-hmm. And I will admit that the full transcript wasn't included, but the relevant parts displaying how the expert's testimony was important to my client's case was included.
Okay, fair enough.
And then, as I said earlier, it's discretionary whether the judge abused her discretion on ruling on that. Moving forward onto the deposition costs, a trial judge has the authority and the discretion to award costs or depositions and transcripts if he or she deems it's reasonable and necessary. In this case, the 4 depositions that were taken were of the named parties, the 3 plaintiffs, which are siblings, and of the defendant.
So I have another possibly irrelevant question. Do we look at 93A and treat deposition costs as just a reasonable cost? Or that is, does a trial court do that? Or does it look at Rule 54, which talks about the taxation of costs in the taking of depositions? I'm not sure what the difference is exactly, because if the deposition wasn't reasonably necessary, it's odd to suggest that it might be a reasonable cost, but still it's slightly different verbiage. Do you have any idea how these two things are supposed to fit together?
I don't have any idea of how they're supposed to fit together, looking at it from the 93A standpoint and whether or not it was important and necessary for the trial. That's, where we're moving to claim the cost on that. And, obviously taking of the depositions and the transcripts is necessary in order to properly conduct discovery in litigation, as well as to adequately prepare for trial strategy. Therefore,
but do you think that if 54A isn't met, a deposition can still be a reasonable cost under 93A?
I guess if perhaps you can't have one without the other. So I think 54A wouldn't need to be met in this case. And then finally, the third.
The problem I'm having with that is one's a rule and one's a statute. You know what I mean? The statute says, give reasonable costs. So where does some rule committee get off saying, you have to do X or Y, like the statute says? I mean, this is really, at this point, really angels on the head of the pan, particularly in a case like this, where this is the tip of the tail, not the dog. But
so moving forward, the statutory costs, that's a de novo ruling, and that's actually awarded for a prevailing party, and no judicial insight is needed for that. And actually looking at the judgment from the jury finding, those statutory costs were awarded, but they somehow fall off afterwards. So we're looking to have those added back on.
Does your motion for costs that we're reviewing include that?
Yes, Your Honor, it does. And accordingly, on all 3 costs that we're looking, the plaintiff requests that the court award these costs in relation to the litigation.
Okay. I'm not seeing any further questions from the panel. The issues are interesting, but they're discrete. And so you've outlined them all in your brief. If you don't have anything else to tell us, you can rest on your brief. It's up to you. You still have 5 minutes.
Your Honor, I'll rest on my brief, and thank you all for your time.
And before you both leave, on behalf of the panel, we would like to wish you a very safe and very healthy new year.